Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again with a new video on your legal current affairs for your CLAT and AILET for 2022 and also for some people who are appearing for CLAT 2023. This might be a video that you want to watch, right? So if you are not like part of our channel, please hit the subscribe and like button also, so that the people who are making videos for you guys are also motivated enough to make more videos, right? And if you are not a part of a Telegram channel, do make sure that you are subscribing to our Telegram channel for all the articles, news updates, and all the free advice that you get from all the mentors all around the globe, that what you should do for your CLAT and AILET, right? So do make sure that you are subscribing to our Telegram channel also. Now, coming to the first news for the day. What is the first news? So, the Karnataka High Court has given its verdict on the hijab ban, right? So, there was a lot of controversy that was going regarding the Karnataka hijab ban that was put up by in the educational institution. So, on 15th of March, there was a 3-judge bench of the Karnataka High Court that has given a verdict on the petition that was related to banning hijab in Karnataka's educational institutions, right? So the High Court has upheld the Karnataka government's prescribing wearing of uniforms in schools and pre-university colleges as per the provisions of Karnataka Education Act of 1983. Now the High Court has also ruled that wearing hijab by Muslim women is not a part of the essential religious practices in Islam. Okay. Now, they have also said that the right to wear hijab is not protected under the right to freedom of religion that is guaranteed under Article 25 of the Constitution of India, right? So the court has also said that prescribing uniform for the students neither violates the right to freedom of speech and expression that is enshrined under Article 19(1)(a) of the Constitution of India, nor it takes away the right to privacy that is guaranteed under Article 21 of the Constitution of India. Right? So the court has also straightforwardly said that a ban on wearing hijab in educational institutional is a reasonable restriction which is permitted by the Constitution, and the students cannot object to it. Okay, so this was a straightforward verdict that was given by the Karnataka High Court. Obviously, this might go till the Supreme Court, and the Supreme Court might have a different kind of a hearing, but I don't think so. It might change a lot, but that's what the court has said in Karnataka regarding the hijab ban. They have upheld the order of the government in as per the provisions of the Karnataka Education Act, and they have said that neither Article 25 nor Article 19(1) nor Article 21 is being anywhere hampered in this kind of a decision. So I hope everybody is clear with the Karnataka High Court verdict that has came up on the hijab ban, and they have said they have upheld the order of the government, and they have said it's fine. It is a reasonable restriction. It has been considered as the reasonable restriction which is permitted by the Constitution, and the students cannot object this particular kind of a ban. Okay, now coming to the next part, that is that the new census rules have come out. Okay, so the gazette notification for the census rules have come out on 11th of March. The union government has amended the census rule of 1990. Okay, so they have made so the changes have been made to clause C of rule 2 of census rules of 1990. They have made the changes in the terms of election forum and self enumeration that have been included in the schedule of questions to be asked during the census. Okay, so that is something that is there. Through this amendment, the census rules allow online self enumeration in the upcoming census and national population register, that is the NPR. Okay, now the announcement regarding the self enumeration was first made in 2020. Now it has been notified through an amendment, so you can see that. Gungun has asked me that she's a student of Pratham and confused where to start legal affairs and how. So I would recommend, Gungun, that you start it from the legal current affairs compendiums that we have given you. You should start covering them from the month of April if you are writing for 2022, and if you are writing for 2023, then you can start from the month of December itself, right? So I hope you understand that you need to read the legal current affairs compendium. Okay, so you can start with the compendium. That is the first step that you should always take if you are preparing for legal affairs. Now you have understood the new census rules that have come out. So the next news of the day is the Telecom Regulatory Authority of India, right? So that is also called TRAI, right? So the TRAI Act was passed by the Parliament in 1997 to regulate the telecom services in India, right? So if you know, there has been a lot of spectrum cases that we have seen around 2G, 3G spectrum. 2G spectrum was a big scam that we have seen. Kanimoji was the person who was involved in that scam. So the 25 years of TRAI Act was to commemorate these 25 years of the journey of the Telecom Regulatory Authority of India. A seminar on the 25th year of TRAI was said to the way forward to the stakeholders, that is the telecom, broadcasting, IT, ERA and Aadhaar companies. Okay. Now the background of TRAI. What is the background of TRAI? In 1990s, the Indian economy saw the coming up of private telecom sectors for the industry, and to regulate the private sector, they found that there is a need for an independent body, right? So accordingly, in 1997, the Telecom Regulatory Authority of India Act ordinance was passed to establish the Telecom Regulatory Authority of India. Now the ordinance was later replaced by TRAI Act of 1997, which was passed by the Parliament. So Telecom Regulatory Authority of India has completed 25 years. So that is a big deal for us, right? So because telecom sector has grown from a lot of places, and we have seen a huge revolutionary change in telecom after the incoming of Geo also. So that is something which has changed the entire telecom game itself. Okay, so Gungun says that 2022, sir, what is required to make notes, or I have learned complete compendium. See, so both are important, Gungun. If you are looking for general current affairs, then you have to go for the current affairs compendium. But if you are looking for legal focused news, then legal current affairs compendium would suffice for that, right? So it's your call. If you have less time, you don't think so you'll be able to read the general compendium, then you can definitely skip on it for once and start with the legal current affairs compendium. That will be definitely helpful for you. Now coming to the next news for the day, that work from home, right? So work from home has taken up a lot of debates in the administrative law functions now. So work from home under Maternity Benefit Act can be availed only if the nature of the work permits so. Okay, so the Karnataka High Court has reiterated that maternity benefits to an employee to work from home under Section 5(5) of the Maternity Benefit Amendment Act of 2017 could be only given if the case where the nature of the work assigned to the women is such that is possible from work from home, right? A single judge bench, Justice R. Devdas, while refusing relief to an employee working with semiconductor technology and applied research. Okay, so that was the case. So they have said that they can do it if the nature of the work is so. If it's not, then there's no work from home in that scenario. Now coming to the next case for the day, that is that the Juvenile Justice Act. Okay, so the child cannot be automatically tried as an adult even if it commits a heinous crime, right? So if the child has committed a heinous crime like rape, murder, anything of that sort, so he cannot be directly or automatically tried as an adult. Okay, so that's what the Juvenile Justice Act says. So the Bombay High Court recently in a criminal revision application dealt with a question: when does a child in conflict with law qualifies to be treated as an adult, right? So this was the point of discussion that was brought in the Bombay High Court. Now there was a single judge bench of M.G. Salvaikar who noted that under Section 15 of the Juvenile Justice Care and Protection of Children Act of 2015 has to make an assessment into heinous crime to determine whether the child in conflict with law is to be tried as an adult or not. Okay. Now section 2 subsection 12 of the Juvenile Justice Act defines child who has not completed 18 years of age. As per section 2 subsection 13, child in conflict of law means a child who is alleged or found to have committed an offense and who has not completed 18 years of age. ठीक है, तो जिसने ऑफेंस कर दिया, कॉन्फ्लिक्ट विद लॉ में आ गया, उसको कहते हैं चाइल्ड इन कॉन्फ्लिक्ट विद लॉ. नाउ इन सेक्शन 2 subsection 33, heinous offenses are being defined, to which is defined as the offenses for which the minimum punishment under the Indian Penal Code or any other law for the time being in force is for 7 years or more. ऐसा कोई भी क्राइम जिसकी पनिशमेंट 7 साल या उससे ज्यादा दी जाती है, उसी को एक हीनियस क्राइम की डेफिनेशन में लाया जाता है. राइट. सो बेसिकली the person cannot be tried as an adult automatically even if he has committed a heinous crime. That's what the Juvenile Justice Act also says. So the person has to be brought in front of the court and they will do the assessment that whether the person has to be tried as a like child and with conflict of law or as an adult. It is done after the assessment. It cannot be done automatically. There has to be an assessment that needs to be done in such a case. I hope everybody is clear. If you are clear, please don't make sure that you hit on the like, share and subscribe button so we know that you all are understanding what all things are being imparted on these videos. Now coming to the next case, that is that adopted son is entitled to take adoptive mother's caste even if biological father's records are not available. Right. So this is a genuine case. Right. Observation was put that the adopted child becomes a family member of his adopted parents in all respects. Right. The Bombay High Court directed authorities to issue a caste certificate to an 18-year-old based on his mother's scheduled caste identity. Right. Because he didn't know whose biological father is and he's been adopted by the person. So he's been adopted in all respects. That's what the court also says. Now, the bench of Justice Sunil Sutra and G.S. Sampath held that an adopted child would be entitled to take the caste identity of his adoptive mother. And despite the caste authorities insisting on making child's biological father's records available. So they don't have to come up with the child's biological father's record to get a child's caste certificate because the child is a adoptive mother's son. So definitely he can claim the caste of his mother rather than going for a caste certificate for his biological father where the records are not available with him. Okay. So one of the effects would be that the child would not get the identity of mother and particular caste of the mother. He would be without identity throughout his life. Similarly, very purpose of adopting the child by the petitioner being a single mother would stand frustrated in our opinion. Such a situation could not be envisaged by the law, right? So that is something which needs to be covered in this scenario. Sir, how to cover YouTube sessions, sir? You are covering February legal affairs. So I have made different videos for February, March, November. So Gungun, you can go and watch all of them. But I will still recommend you to read the legal compendiums because we do not discuss everything in these videos. There are some parts of it that are left for the students to read also. So definitely you should read them very, very carefully. That would be my recommendation to you. Hi Keshav, good afternoon. I hope you are doing great. Right. Hi Mahi. Hi Keshav. Hi Gungun. I hope you are being able to understand what is being taught till now. Right. So the last is that the illegitimate child is also entitled to compassionate appointment. What does compassionate appointment means? When the person who's working in a company or an organization dies on duty, right? So that is what the compassionate appointment means. Now, the illegitimate child means the child that is born out of the wedlock is called an illegitimate child according to the law. Now, the Chhattisgarh High Court held that even the illegitimate son or daughter is also entitled to compassionate appointment. Now, Justice Sanjay K. Agarwal has referred to the case of Union of India versus V.K. Tripathi, where it was held that the legitimacy of a child born from a marriage which is null and void is a matter of public policy. So as to protect a child born from such a marriage from suffering the consequences of illegitimacy. Hence, through the marriage may be null and void. A child who's born from the marriage is nonetheless treated as legitimate by subsection 1 of section 16. तो आप समझ रहे हो, वो फर्क नहीं पड़ता कि वो वेडलॉक से पैदा हुआ है कि नहीं हुआ, चाहे उनकी मैरिज नल और वॉइड क्यों ना हो, बट उस चाइल्ड को लेजिटिमेट का स्टेटस दिया जाता है अंडर सबसेक्शन 1 ऑफ सेक्शन 16. Okay, so it doesn't matter. So the child will get compassionate appointment according to Chhattisgarh High Court, and they have also referred to a previous case of Union of India and others versus VK Tripathi, so where it was stated the same manner, right? So I hope everybody is clear with these cases that we have discussed, and these are some important news that you can see, and they I'm sorry, they also give you a perspective that what to look ahead and what kind of cases can appear in your exam, right? So the next is that the competency certificate of a child witness is not mandatory if it understands the court's question and answers rationally. Okay, तो अगर एक बच्चे से क्वेश्चन पूछ रहा है कोर्ट, तो उसका आंसर अगर बच्चा दे पा रहा है और वो समझ रहा है कि कोर्ट उससे क्या पूछ रहा है, तो उस कॉम्पिटेंसी सर्टिफिकेट की उस चाइल्ड विटनेस की कोई जरूरत नहीं है, right? So the Allahabad High Court has said that the competency certificate of a child witness is not mandatory if the child gives rational answers to the court and questions and his testimony is unshaken, inspires confidence of the court. ठीक है, तो अब आप समझिए, अगर वो ऐसी बात बता रहे हैं और कोर्ट को लग रहा है कि हाँ, he is not lying and he's telling the truth, and the child is very confident, he's understanding what kinds of questions are being asked to them, then definitely there is no competency certificate that is required by the child. So the unquote quote, what the court says is that nowhere it is provided that the certificate regarding the competency of child witness is mandatory. If it is recorded, it is so far so good. But if the court has to put the question to understand his intellect, to understand the question, and if he's replied the rational answer, thereafter his examination was recorded without regarding the certificate regarding the competency of witnesses. Okay? So the rationale depends on the child. They will see the child, so that competency certificate is not gonna make a difference in this case. I hope everybody understands what is being told in this POSCO case, right? So this is it for today, guys. Thanks for joining this live session. I hope you understood a lot about some legal affairs. And if you have just joined the video, please make sure that you hit on the like, share, and subscribe button. And if you haven't watched the video completely, go back and watch the video and also tell us that how do you like, and also don't forget to hit on the bell icon for these regular updates. And do make sure that you're wearing your mask and using your hand sanitizers and also maintaining social distancing. If you are someone who's above the age of vaccination, then do get yourself vaccinated and also protect yourself from any other diseases that are coming up. So keep smiling, keep preparing, and thanks for joining this live session. Hope to see you all again on Friday itself with a new video that we'll be discussing some new things on this channel again. Right? So thanks, guys. Thanks for joining this live session. Take care of yourself and hope to see you all again very soon.